All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
All right, folks, let's dive into this courtroom drama. The judge calls the session to order and Mr. Thornton steps forward to present his case. He explains that he has custody of his son, AJ, and has been making arrangement payments to Miss Hernandez. But things have taken a turn for the war. AJ has gotten into serious trouble, including burglary and a police chase accident. The judge listens carefully, asking about changes in living arrangements or expenses. Mr. Thornton's frustration is palpable as he reveals the financial strain caused by A's actions. This case is about more than just money. It's about responsibility, legal obligations, and the challenges of parenting a troubled teen. Let's see how the judge handles this complex situation.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Okay, Mr. Thornton lays out his case in detail. He explains that Miss Hernandez has moved out of state, quit her job, and her insurance no longer covers AJ. He's shouldering the financial burden alone, including medical costs, court fines, and damages from the accident. The judge reminds him that they agreed to no child support during mediation and asks if there's been a material and substantial change. Mr. Thornton struggles to prove a scientific change as AJ has always lived with him. His frustration grows as he realizes the legal hurdles he's facing. This section highlights the emotional and financial stakes, with Mr. Thornton's determination to seek support clashing with the judges.
In that aspect, and the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes,
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
that's very disappointing. So she's just...
The judge takes center stage, explaining that to modify child support, There must be a material and substantial change, such as a change in living arrangements, educational needs, or income. She points out that none of these changes have occurred since the mediation agreement. Mr. Thornton expresses his frustration, feeling that Ms. Hernandez is free of any obligation. The judge clarifies that the agreement was mutual and that the law requires significant changes to alter it. Her no-nonsense approach leaves no room for ambiguity, and Mr. Thornton is left disappointed. This is the heart of the drama, with the judge's sharp legal reasoning and Mr. Thornton's emotional plea, creating a tense and compelling moment.
Of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely. Yeah,
As far as I'm concerned, no, there's nothing you can do. Yeah.
all right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay,
That's about it.
okay. Well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
The judge reiterates her ruling. Mr. Thornton cannot receive child support under the current circumstances. She emphasizes that the mediation agreement stands and dismisses the case. Mr. Thornton thanks the judge but leaves visibly frustrated, knowing that the financial burden will remain on his shoulders. The judge's final remarks drive home the importance of legal agreements and the need for significant changes to modify them. This part delivers the resolution and key takeaway, leaving viewers with a clear understanding of the judge's decision and the challenges of navigating child support laws. Next voice. For now, let's break it down from a legal perspective. This case highlights the importance of understanding child support agreements and the legal requirements for modifying them. The lawyer explains that under Texas law, a material and substantial change is necessary to alter a child support arrangement. In Mr. Thornton's case, no such change occurred, so the mediation agreement remained in effect. The video ends with a call to action encouraging viewers to share their stories and subscribe for more insights. This case is a powerful reminder of the complexities of child support laws and the importance of seeking legal advice when facing such challenges.